a battle where the norms should be. What is communication to the public? What is a parody?
It's a preliminary.
Yeah. Well, the preliminary, I wouldn't get hung up on the word. That's just a technical term. So the preliminary reference means the national court doesn't know what to do. So that's why it's preliminary. So they ask the court, and the court then says, okay, parody is an autonomous European concept.
It should be authority.
And then becomes authority. So then we know now it's a European concept. It has that meaning. The meaning of parody is now it has to be in dialogue with the work. Okay, so it can only be a quotation. It can only be a quotation if it's in dialogue with the work you quote. Okay, so then the national court has the meaning of the concept, and then it applies to the facts of the case. So that's how it works.
If the member state cannot find the preliminary references, how would they do? Just use the domestic law, or?
So European law works in two ways. So you've got regulations which have direct effect. Okay, and you've got directives which are basically common standards. So directives have to be implemented into national law. So essentially, the smartest way is essentially just copy the text of the directive and put it into national law, because otherwise, but many countries, they have existing laws in that area. They don't want to do that. So what they do is they chop and change. So they add a few provisions somewhere in the existing law, and sometimes they change versions. Anyway, that means potentially you have then 27, 28 member states each making different decisions on the same thing. Pirate copying, we have to charge. Let's say does a copy on my computer fall with the pirate copy exception? And does that have to be compensated by a levy? Okay, so it may then be in some member states, there's a levy on the PC I buy, in others not, and that then affects the internal market. Okay, so that would be then a situation where you get in one of the member states a dispute, and it goes to a court, and the court looks at what the European Court has said and thinks, I can't make up my mind, I don't understand what they mean, and then they pose a question. So that's how it works. So, as I say, so what we try to do now is once a reference has been made to the court, the member states can intervene, and the European Commission can intervene. Okay, and they can intervene by writing what is called written observations. So they give a reasoned legal document to the court, how the basically advising the court how the court should find. Okay, so member states can do that on every single reference to the court, but it's obviously labor and resource intensive. Somebody has to, there needs to be an agent. Typically, a government appoints, a barrister or a firm of solicitors as their agent in the court. And they have to be paid. They have to write an opinion. They have to clear the opinion with the government, and then they have to submit it, and it all has to happen quite quickly. But there's the moment when the reference has taken place to the court, and before the hearing, where member states can offer these written observations. So these written observations have been treated as confidential in the past. So while they are open in the court, so if you actually go to the court in the hearing, you can hear them, but they are not published. So that makes it very hard for us as researchers to work out what is actually the interest of the governments pursuing in writing these observations. So we had to go through a process you don't want to endure ever, but essentially, so some governments were friendly and they had cooperative agents that just gave us what they'd done, and it's fine. But many others didn't, so we had to file freedom of information requests in many countries, and then we created these questionnaires where they had to fill out, what they recommend answer to each of the questions was, and it took us, kind of 3 years to complete the data sets. But it's exciting stuff because nobody had done it, and we know much better what the member states' relationships to the court is. So I don't want to bore you really with what we've all done because it's extremely complicated. What I really want to show is just this graph. So in the end, so what we did is, well, maybe I'll show you this one here. So this is the example how we code it. So this is the Painter case. Painter case is an example. I don't know if you're familiar with this. It's an Austrian reference. It's about a photograph taken of a girl which was taken hostage and then held in captivity for 10 years. Okay. So a photographer took a photo of that girl while she was at school before she was taken hostage. Okay. Then she disappeared from the world for 10 years. Then she was released, and the press obviously was hugely excited. There were lots of reports, and in their news reports they used this school photograph. Okay. So the photographer of the school photograph said, you know, I'm the copyright owner, so you can't publish that photograph without permission. Okay. So this is the set of questions which the Austrian court asked of the European Court of Justice. Gives you a feeling for how the system works. Okay. So the first one is really about the status of you know, portrait photographs. So you know, are they copyright works? You know, are different originalities standards applied? The Austrian court. I don't know which level it was. It was probably was the highest. So anyway, you get so not all of them are copyright questions, okay? But most of them are. So what we then did is we coded in these columns what so opinion is the Advocate General, so what the Advocate General advised the court to find. Then the judgment is what the court actually found. So you know, is the InfoSoc applicable where the author of the published photo is not named in the reports? Okay, so so that's in news reporting. Normally, you have to cite your source to get the exception. Okay, so if the author of the photograph has not been credited in the newspaper report, you know, does then Article 5.3 apply, which is one of the exclusive rights. Okay, so the opinion says, you know, it doesn't apply, and the judge says no, it doesn't apply, and that's not favorable to right holders. It's favorable to users. Therefore, called yes. And here are now the 3 countries which offered written observations. So Austria, AT, said no. Estonia said no, and Italy said no, and the European Commission also said no. So on this question, you know, they are all in one view, and the view is in favor of users. So we did that for all, well, the sample we used here was 42 cases. So we used only the cases which had been litigated at least 5 times. So concepts which were litigated at least five times, because we thought they point to a normative void. Okay, so so that's really the only thing which you need to take away from the study. So each time the opinion of a member state was in agreement with the court, they move one up. Each time it's in disagreeing with the court, it moves one down. The size of the dots indicates how many observations were made by member states, and left and right means whether the intervention of the member state was in favor of the right owner or of the user intermediary. And the findings are pretty striking. So these basically is the line. You know, there would be no correlation between the submissions and the court's findings. And we find that overall the court, you know, moves with the collective opinion of the member states most of the time. Most of the time, if you look at all decisions as a whole, it moves with the opinion of the member states, which is, from a political science perspective, very interesting, because it indicates precisely what it said earlier on, that courts are sensitive to the context in which they operate. They're not entirely, you know, a separate field of logic. And then we find that the European Commission knows very well what the court will say, okay? Or if the other way around, the court follows the European Commission. So the advice of the European Commission is, you know, by far the most influential to the court. And it tends surprisingly to be favor users. So we didn't expect that at all. But of the member states, there's an extreme outlier, which is France. So France almost always argues in favor of right holders, and it's highly successful in persuading the court to adopt its views. And there are some countries which do really badly. So they have very little luck in persuading the court to follow the lines that goes in. So Austria, Greece, not doing extremely well. And then there are some small countries which are actually very influential. So who would have thought that Finland and Czech Republic are actually quite powerful actors in Portugal? Okay, so I think this is quite exciting work, and it lifts in some ways the veil on how court system works. I mean, it has dangers, yeah.
I wanted to ask something which is maybe more general, but still applies to that. What if I'm on the picture, but someone else took the picture? Who's the right holder of the picture? Because actually, the person who takes the picture needs my permission.
Yeah, that has changed over time. So in the beginning of photography, the sitter was still had a potent role, but now it's straight. The copyright, the photographer is the owner. Okay, so any immediate questions on this? I mean, it's complex stuff, and but if you've got any questions,
Are there any sort of particular reasons why some countries are more successful than others in some areas? Because in the paper it said that Poland was particularly unsuccessful for unclear reasons, whether there are clear reasons for other countries.
We haven't really looked into that, and it's obviously also quite dangerous to say things. But after our studies, some other people have now started to target particular people. With their identified names in the European Commission writing opinions, and so it becomes quite personalized. And it's probably the quality of legal reasoning, I would say. So it's probably that's a big part of it. So how much, how good are the people, how many resources do they have in preparing an opinion, I think must play a part. But we, in many cases, we only got these questionnaire answers, so we don't have the full text. Okay, so let's do a break, 10 minutes, and then I do an introduction to the Digital Single Market Directive, because it will feature quite in the foreground of tonight's lecture. So Catherine Styler, who gives the lecture tonight, she was for 20 years a member of the European Parliament, and she was the vice chair of the Internal Market Committee. And the Internal Market Committee had joint responsibility for Article 13, which then became Article 17 of the Copyright and Digital Single Market Directive. And it was very controversial under the, because it was named the filter article, okay? So that this article was deemed to oblige platforms to install filters preventing the upload of content to their platforms, which may or may not be copyright infringing. Article 17 went through many iterations, and we played a certain part in that. If you go on the Great Safe site, there's documentation of what our interventions in the process. If you click on the blue kind of banner with Copyright Directive. But what it turned out to be is, it's a mess of a provision. This is just the beginning. So Article 17 is pretty long, and it's pretty incomprehensible. But you need at least know something about it to understand what the debate will be. about. So let's go through it bit by bit. So the directive tried to do, as it said in the title, it tried to contribute to creating a digital single market, so there are no borders or barriers for copyright works to be trading within the European Union. But there are a number of provisions in there which really don't have to do with harmonizing exceptions or harmonizing what you would think facilitates the same scope of protection across the union, and some of them are essentially a means of industrial policy. So we've got a press publisher's right, which is supposed to be supporting the newspaper media, and we've got Article 17, which is supposed to support content industries against the big platforms, YouTube in particular. So why this is helping the digital single market is not immediately clear. But anyway, so up to this time, the law here was the e-commerce directive, and the e-commerce directive, important here is Article 14. So the e-commerce directive is from 2000, and in some ways it's equivalent to the Digital Millennium Copyright Act in the US. And this provides this so-called safe harbor. So if a hosting provider stores information that the recipient of the service uploads, okay, then the service provider is not liable for that information on the condition that the provider does not have actual knowledge of illegal activities. Okay, so it's this here, Article 14 of the e-commerce directive. And then we've got the clause that the provider, upon obtaining such knowledge or awareness, acts expeditiously to remove or to disable access to the information. Okay, so that gives rise within the European system to something which is quite similar to the notice and takedown system in the US. So essentially, liability is only established if there's failure to comply with takedown after a notice has been received. So in the US, that system is formalized. So the system tells you precisely how the notice has been served. You can contest the notice. You have to give the URL and so on. So there's a formal process. European law leaves that to member states. So how you acquire the knowledge, which makes you liable, that's not set out by the European directive. Okay? So that's the current situation. And that's, as I say, sometimes called the safe harbor. So it means you can start a new kind of service to which users could upload material without worrying whether the stuff they upload is, in some ways unlawful. Okay, so if you move on to the new directive, which now has got 2 years to be implemented, we see that it's not in the right place. Yeah. So what we have now here, and that's important, the open line. Yeah. So member states shall provide that an online content sharing service provider performs an act of communication to the public, or an act of making available to the public. So these are exclusive rights under the Information Society Directive, when it gives public access to the copyright protected work or other protected subject matter uploaded by its users. Okay. So the idea here is now that the service provider, a particular type of service provider, the online content sharing service provider, becomes primarily liable. So the platform itself becomes a direct infringer for unlawful material that appears on their platform. Okay. So if you get put into that position, what does that require you? I mean, if you want to start a new service, okay, you have an idea. Okay, yeah, I want to focus on advertising from the 1950s, or I look at early video games and I create a platform, users upload stuff there. Okay. So what would be your WOI as a platform? Well, your WOI would be that somebody uploads unlawful stuff, isn't it? Isn't it? So how do you stop that? By filtering. By preventing it appearing in the first place. So how do you know what to filter? So how do you know what is potentially unlawful? So in the copyright sphere, the notice and takedown had a system there. So basically the right owner had to state, we own it, take it down. So how is this kind of preventive measure going to work? And they haven't worked out how that's going to work. So that's why the provision is such a mess. Okay? But let's first look at who is the target. Okay? So we basically, why the information society, the e-commerce directive speaks of information service providers. So in a wide sense, the best way to understand that provision is as a carve-out. Essentially, there is a new category, a smaller category of service providers, which no longer falls under this liability shield. And in order to find out what is meant, you have to go to definitions. So that's why I pulled out here Article 2 of the directive. So this gives you the definition what this new category is. So these new obligations and the new liability applies to the following type of services. So they're online content sharing service providers, means a provider of an information society service. So that's the language of the e-commerce directive, of which the main or one of the main purposes is to store and give the public access to a large amount of copyright protected works. Okay, the main or one of the main purposes. So that would cover what type of thing? It obviously would cover Facebook, Twitter, Instagram, YouTube, Flickr, whatever. I mean, you give me your own names. Anything you do all the time here. Yeah. Anything where you put photos or text up is always a copyright work, isn't it?
Pinterest?
Yeah. Yeah. Okay, so it covers services we all use every day. So this is quite far-reaching, and there was obviously a lot of disagreement about this. So in the process of lawmaking, they created essentially a number of exceptions, means a number of services which are not online content sharing service providers, OCSSPs, those which are not, okay? But these are listed here, okay? And they're listed with a such as phrase. So there may be others. So they're listed here by way of example. So those which are listed here, which are not covered by this new liability regime, are not-for-profit online encyclopedias. So that would be Wikipedia, okay? So Wikipedia, even though people, it's users writing them, so they put copyright protected material up there, yeah, potentially. They're not supposed to do it, but they potentially do it. It's not covered because it's a not-for-profit online encyclopedia. Not-for-profit educational scientific repositories, so that would be the kind of preprint repositories for scientific work, e-prints in Glasgow. Open source software developing and sharing platforms would be GitHub, that type of thing. Provider of electronic communication services as defined in Directive 2018, so I think these are messaging services. Then we've got online marketplaces, these are eBay type of things, Alibaba things. Then business-to-business cloud services, Dropbox. Okay, so is there anything in common between all those which are not covered? I'm not sure. Okay, so but this reflects kind of the political turmoil of it, because it was seen in the political debate that this kind of broad liability established would capture suddenly a lot of services which are not able to or shouldn't be required to filter. So, let's always lift this back up. So, Article 1, as I say, states this new primary infringement. Then Article 2, that says that if there's an authorization, so if there's a license to put the material up, so if the record labels give YouTube permission to put recordings up, then that covers what the users do with it. So if there's a mashup or a GIF or then that user-generated content would be covered by the license given. So that's supposed to be a user-friendly measure. And then 3 says that the relationship to Article 40 of the e-commerce directive, which we just looked at. And now we come to the stuff where it really no longer gets up to then. We can just about understand what's going on. So number 4 is now how you can avoid this liability, this new infringing primary infringement, which comes your way as a platform. So you can avoid filtering in the following way. Well, we can avoid buying a license for material which users potentially upload to your service. Okay, you can avoid that liability by making best efforts to obtain an authorization. So here you need to know, what means best efforts. Who do I have to contact? So, if I create a new service and I may get images, texts, I might get multimedia work, I might get software. So for all of these categories of work, I have to find all the right holders, or what counts as best efforts. And is there somebody who might be able to license me? Okay. So the nature of user-generated means the user is uploading content. So how do you as platform know, what potentially goes up there? So how do you know where to go to get a license? So that technical problem has not been addressed at all. So that's left to national implementation, and that will be a complete utter nightmare. So I made best efforts to obtain an authorization in accordance with high industry standards of professional diligence. Okay, so you can already see the reference to the Court of Justice. Okay, made best efforts to ensure the unavailability of specific work. So what is best effort preventing the unavailability? So does it mean I write down, we don't want any software uploaded to my platform? Is that best effort? Or you are responsible for only uploading lawful material. Is that best effort? We don't know. Okay. Then we move to a kind of notice and stay down system. So you made best efforts in accordance with high industry standards, and then you act expeditiously. It's again the language of the e-commerce directive. Upon receiving a sufficiently substantiated notice, so we don't know what that is, from the right holder to disable access to or remove from the websites the notified works. And make best efforts prevent their future uploads. Okay, so essentially, if you make best efforts to get permission, a license, and you try to make stuff unavailable in the first place, and then if you're notified, you keep it down. If you meet those 3 conditions, the liability doesn't apply to you. Okay, so if you want to avoid the new primary ability as a platform, this is what you need to do. So this does sound quite hard work, but it may be possible. But each member state may do this differently. So now these kind of provisions have to be translated into national laws. So what's the nature of information a right holder has to provide in order to trigger, the notice and stay down mechanism? We don't know. What are the standards? Do we need a URL? Need to show that you actually own the rights? I mean, it needs to be the database of rights which are, not supposed to appear on user-generated platforms. Nobody knows. So this will, go for decades. You know, believe me. Anyway, so I don't want to go to the other paragraphs, and there's still more stuff. There's something about redress mechanisms. So what users can do if you think you've tried to upload something and it hasn't appeared or it's been filtered down, and you think it's lawful either because you've done it or because it's within a copyright exception. And copyright exception is particularly pertinent here, isn't it? Because a lot of user-generated platforms, they use, the stuff users upload are potentially within copyright exception of parody or quotation. So you think, okay, so what I've put up there is no copyright infringement, therefore, the platform should have tolerated it, and there should have been no need for a license. It includes copyright protected material, but it's with an exception, so therefore no license is due. So we don't know what the mechanism is there. So if there, is there a counter notification? How is that done? Who judges whether is it up to the platform to decide whether it's within the, so do the platforms become the arbiter what the scope of the copyright exception is, which is, platform is a private party, or is it a matter of law? Needs to be an appeal process? Does it go to a court-like? So each member state could do that differently. They could open a tribunal, they could have an executive kind of mechanism. So again, we have no idea how this is going to end up. So anyway, it's something to look out for. I mean, I think it's globally important because it's a paradigm shift. It's the first, the first state or state-like jurisprudence who is introduced, this change in liability. So it may have global repercussions. It certainly raises, the obligations on platforms if this is accepted as a way of regulating that space. Okay, so what I would, I'll leave it at that because the lecture tonight, will be essentially part of what you heard today. But I would require you to the next half an hour, try to read yourself a little bit into the politics of that particular provision, because then you will understand much better what happens tonight. Okay? Thank you.